Krista Hermance. Okay, so what is the difference between a living will and an advanced healthcare directive? This is a question that I get all the time. So a living will in the state of California, which is where I'm licensed to practice, is basically just a document where you say that if something were to happen to you and you were unable to make healthcare decisions on your behalf, you are identifying an agent that is able to make these decisions for you. In your advanced healthcare directive or living will, it also allows you to state certain end of life decisions. So, do you want to be buried? Do you want to be cremated? Do you want prolonged life support with extreme measures, or would you want to be taken off life support? Do you want to do any type of organ donation for transplant purposes or medical research, or none at all? And so that's what a living will is. When somebody refers to a living will, that's what they're referring to is those healthcare decisions. It's that document. It is not a will like a last will and testament, as some people may know it, or a pour over will, or just a will. A living will is completely different from that, and I know there's a lot of confusion with that. And where a living trust comes in is this is also known, some people just call it a trust. They might also call it by its legal name, which is a revocable living trust. And what the revocable living trust is, again, completely different, is basically just an agreement where you, as the grantor, which is the creator of the trust, put specific instructions in writing to the trustee, which is the person who agrees to hold legal title to all of the assets in the trust. Some people know this as the executor. And they do all of the instructions in the trust where the assets are in the trust for the benefit of the beneficiaries. So while you are alive and you have this revocable living trust, you are all three of those roles. You are the grantor, meaning you created it. You are the trustee, meaning you are in complete control and in charge over all of the assets in your revocable living trust. And you are also the beneficiary. It's all there for your benefit. So you're not losing any control when you have a revocable living trust. These documents are completely different things. They have completely different things that they do. They have different meanings for what they allow people to be able to use them for, but they are part of a complete estate plan. And so when I talk about estate planning, these are documents that make up an estate plan. So an estate plan includes the living will, it includes the living trust, it also includes a pour over will, right? So a completely separate document. It also includes a power of attorney, HIPAA authorization, certificate of trust. So all of these documents have different roles, things that they do, that if something were to happen to you, you have legally documented what you would want, right? Who you want making decisions for you, the type of decisions you want, what stuff you want to happen, how you want things going to your beneficiaries or your heirs or whoever it is. That's why estate planning is so important. Without these documents, that's where court intervention is sometimes needed to be able to allow the court to say this is what is going to happen. Because if you don't have it legally documented and something comes up, and I see it all the time where there isn't documentation done and we have to go to court. And so that's one of these things, is making sure that your legal wishes are documented the way that you want it. If you need help getting any of this stuff in place, please schedule a free 30-minute phone consultation. Remember, we are licensed in California, so we can help clients virtually throughout the state of California. If you are not in California and you need help, send us a message and we can refer an attorney to you in your state to be able to assist you. I hope you have a great day. Thank you.